So this morning we are going to be covering the responsible individuals list, the how and why in this webinar. It is being recorded just so you're aware that it will be available after this. And we'll go ahead and get started. All right, so as always, these webinars are developed through funding from the North Carolina Division of Social Services. We at the Family and Children's Resource Program work in partnership with the teams from the division, and we are happy to be able to host these from, typically we're doing this from the UNC School of Social Work in our computer lab, but we are doing this from home at this point. So the goals of this webinar, by the end of this, we hope that you will be able to do the following. One, to be able to explain what the responsible individuals list is and the role it plays in child welfare in North Carolina. And we would like you to be able to describe the steps involved in placing a person on the responsible individuals list, especially as it relates to case decisions, legal process, and data entry. As most of you seem to have already figured out, the best way to communicate with us, especially we have got about 220 folks and counting in the room, will be through the chat pod. So please put your comments and your questions in the chat pod as they come up. We'll talk in a minute about how we're going to take care of questions. If you need to communicate with just us, the hosts, you can click on the hosts tab and communicate with us. And you would do that if you were having any technical difficulties or having issues hearing or seeing the content. You can also start a private chat with one of us if you need to speak to us directly just by hovering over our names and starting a private chat. So with questions, whenever we do a webinar, we want to be able to answer as many of your questions as possible, and we also want to make sure that we get through all of the content. So the way we typically handle this is that we've got two folks here monitoring the questions in the chat pod throughout the presentation. There will be times when we'll pause and we'll review those questions to see what the themes are. We will not obviously be able to answer every single question that's typed, but when we see multiples or things that seem relevant for a large group of folks, we'll try to get those answered. We are not going to be answering case-specific questions. That tends to get us down rabbit holes, as y'all know. So please just hold those for your own counties or after this webinar talking with your colleagues. And as I said, this is recorded. This is being recorded, and it will be available on NCSW Learn and also on our website, the Family and Children's Resource Program. And there's the link to our website and the webinars section of that. And just so you know, all previous webinars are archived there as well. So if there are topics that have been covered that you want to review, you can always find them there. Another way to give us attention, to get us or talk to us or communicate with us, is to use the little waving person at the top of the screen. If you click on the arrow next to that waving person, there's a lot of options there. So you can let us know if you need us to speak up or slow down, or you can always give us laughter and applause, which I'm sure Peter and Gail will appreciate at any time during this presentation this morning. So please, sort of your two main ways to communicate with us are the chat pod and the icons. All right. Great. So we're going to go ahead and have folks introduce themselves. First, I'll let you know I'm Laura Phipps, and I am the program coordinator for the Family and Children's Resource Program, which is part of the UNC School of Social Work. We have with us today providing technical support is Philip Armfield, and you may have seen him chatting to you in the chat pod already. He's certainly the person that would be able to help you if we're having any technical problems. John McMahon is also here, and he's going to be monitoring the chat pod and collecting questions so that we have questions to answer during our pauses. And we also have Jonathan Rockoff, who is going to be here as backup technical support. So we're here to help. If you need us, please let us know. I'm going to have our presenters go ahead and introduce themselves. And Peter.
Sure. Good morning. You guys hear me okay? Good to be with you this morning. My role with the division is I supervise the regional child welfare consultants with Jennifer Oshnock. Our teams were formerly known as the Children's Program Reps or CPRs, as well as the Program Monitoring Team. And it's good to be with you guys this morning.
Good morning. I'm Gail Carelli. I'm an Assistant Attorney General with the Department of Justice. There are 3 child welfare attorneys, and I'm one of them, and we collectively support and represent.
Sorry, Gail, go ahead.
Oh, sorry. We represent DHHS Child Welfare, and I actually work closely with Peter's team and Jennifer's team with the county work because I used to work in the county. So now I'm done.
Great. Sorry, Gail. There's just a little bit of a delay, so I'll just keep that in mind as we're moving through this today. All right, so I'm going to turn it over to Peter at this point, and we'll pause a little bit. And
thank you, guys. Again, it's good to be with everybody this morning, and those who know me know I prefer a face-to-face type of thing, and it's much more fun to do it that way, especially to deal with questions. Let me make you aware of a couple of things that are available to you. If you notice under our pictures on the screen in that resource pod, there's a couple of documents that we put together for you. The second one there, the RL Basics, is just kind of a cheat sheet to give you a summary of what we'll talk about today. When you have those basic questions about answering the RL. The webinar slides, excuse me, are also in there as well so that you can download those for future reference when you have questions. The other 2, one of the things that we get consistently to our team is there a tool? Is there some way that we can do this? And you know, if you know Jennifer and I, we're both about tracking cases and moving things along. So we've put 2 examples there, the one that says RL list, the other one that says log blank. And actually we won't take credit. I can't tell you off the top of my head which counties created those, but we did steal them and we keep them in a resource folder. So if you're interested in, because basically what it does, here's the case, here's when it came in, and then it's a checklist of the steps that you need to take when you're completing the RL. So I encourage you to download those resources and keep them available. But again, as Laura alluded to earlier in the presentation, we don't want to get into a lot of case-specific questions because understanding that the RL it's easy to say it's a simple process because, you know, when you look at it written, it is a simple process. But we also recognize that each case that you deal with at the county level has its own dynamic. And so it can make the RL complicated. And so when it comes to case-specific types of questions, if you're genuinely not sure, or if you want to process through, here's where we are with this case, here's what we found, here's where we're moving, that's what the regional child welfare consultants are for. And I just encourage you, reach out to those folks and talk through with them. The other thing I want to say about the RL is that, you know, we talk a lot about, you know, let lawyers make legal decisions, let social workers make social work decisions. This is one of the pieces that we do in social work, especially in child welfare, that we are genuinely driven by both. And so part of the reason, obviously, for having Gail on with us this morning is to talk about what does statute say, especially about notifications and how you engage the court and those types of things. But we also want you to recognize that the RL, when you get to a certain place, is a partnership, and we want you to engage at times with your county attorney, and we'll talk about that when we get to the right places. And the beautiful part is too is that Gail and Andrew and Gina, they are always available as well. If your county attorneys need to bat things around and process through things, you know, we encourage them, get in touch with one of the AGs. and let them talk through what needs to happen. So we genuinely want you to see this as a partnership that everybody's involved in. Okay. So what is the RIL? It's the Responsible Individuals List, and here's what it does. It was created several years ago, and most of you, if you've been around for a while, you recognize we are on our second iteration of the Responsible Individuals List. But there was a need to create a list of folks who had been substantiated for abuse and or serious neglect, so that daycares, schools, any organization that had contact with children on a regular basis could look at a list and say, this person was substantiated for abuse of a child. This person was substantiated for serious neglect of a child. Now again, I think Gail would back up, the statute is pretty clear. You can't use that to determine necessarily employability, but it gives you the bigger picture about who they are. And so the list was created and created in such a way that certain people can access that, right? And that's a separate thing to worry about. The other thing to remember about the Responsible Individuals List, and we're going to talk about the process, is only those cases that are substantiated can go on the Responsible Individuals List, meaning that only those cases that are assigned as investigative assessments along the way. Okay? Gail wants me to mention too that when it comes to the RL as well, the other people that can access that are those that are preparing to license foster and adoptive families. You know, that is one of the places that they access the RL as well to see if this person is fit to be a licensed foster parent or to be an adoptive parent. Okay? The other piece I want you to see is that now on the Responsible Individuals List, we can include non-caretakers who are responsible for human trafficking. Yeah, did you want to throw anything in there about that piece of it? And you'll hear Gail and I back and forth at throwing each other under the bus. So,
thanks, Peter. Yeah, so caretaker, as you know, encompasses a parent, guardian, custodian, or caretaker. We use that word sort of generally, and anybody who isn't that is a non-caretaker. But with perpetrators of human trafficking, the law changed a few years ago, and so our statute had to change. That it really doesn't matter whether the person's a caretaker or not. A perpetrator of human trafficking is eligible for placement on the RIL regardless of their relationship to the juvenile.
and I will say our regional child welfare consultants are hearing more, and not just from like the larger counties that you would expect, but we're hearing more from counties across the state where there are cases of human trafficking beginning to pop up. And so please keep that in mind as you're working. And so a couple of things. Here's the first question we always get, and you know the manual was modified a year and a half ago, and then we redid how it was put on the website so that you could find it. And people are always asking, where is the RIL? Okay. So when you go to the division's website and you pull up the place where manuals and policy manuals and things like that are held, you get this index in front of you. Down at the very bottom, kind of about halfway down, you'll see Appendix 1. Thank you, John, for putting the link there. You'll see Appendix 1 that says CPS data collection. I don't have an explanation as to why it wound up there, except that a big piece of what you're doing with the RL, getting them on the RL, is the data entry piece, right? So this is where it lands. Then when you click that, here's the next screen that you'll get. Right? It'll talk about CPS data collection, non-NC fast, and we'll talk about the difference in a little while later. But about halfway down, you see where it says Responsible Individuals List. If you click that, then it will take you to the process. It'll take you to introduction, definitions, what the statute says, how to handle certain situations, how to handle judicial review, and how to fill out the 5104A. Okay? So that's where it's located, and I don't anticipate that moving or going away anytime soon. Okay? So let's talk about the RL process. One of the things that you'll hear from our team consistently is thoroughness of assessments from the very beginning makes all the difference in the world, right? In other words, we don't want you thinking about RIL only at case decision. Right? We don't want you waiting to case decision to decide, do I need to be thinking about the steps for the RIL? It really needs to start from the beginning. And people that know me know I say this is where you always start, right? Again, a good thorough intake using the form that's in front of you, the structured intake form, to ask all of the questions. What are the allegations? And please, and you'll hear us say regularly, you know, when you ask someone, what are you concerned about, and you write that down, please don't stop there. Right? It's perfectly okay to ask, look at all those questions that are on that form. How can you get more information so that not only are you making the best decision when you get to the end of that form, right, the 1402, but at the same time, you're giving really good information for that assessor who will take it over. So what are the allegations? What other questions do you need to ask? Right? What types of things does someone need to be looking into when they get out there to meet with this family? Right? And then identifying the perpetrator. Again, this is a big part of what we do at intake. Is the person a caretaker? Do they meet that definition? And again, are they a perpetrator? You know, and as you heard Gail say before, the definition for human trafficking has now been added, that even if they're not a relative, and Gail, I don't even think they necessarily have to be living in the home, correct? It's just if they're a perpetrator of human trafficking, we can screen that case in for investigation.
Yeah, that's
And
correct.
so,
Actually, we have to. It's not
right,
optional.
yeah, that's right. That's a mandate. Is if, you know, if you've got someone
Yeah.
that's being accused of perpetrating human trafficking, we have to screen that in and respond to it. Okay. So again, starting with intake, asking as many questions as you can, getting as much information as you can, so that when the assessor picks it up, because the first thing you're going to do when you have that, the more information you have, the better informed you are about, all right, which decision-making tools do I need to use? If I'm looking under abuse, which one? What questions am I going to ask? Right? When I'm looking at neglect, what questions am I going to ask? That type of thing. So that when you get down to decision-making, you can make the best decision, whether it's an investigative assessment, family assessment, and or assigning the time frame. All right, so please don't discount the necessity and the importance of intake, especially as it informs the RIL. All right, because the more you have throughout the life of a case, the better decision you're going to make when you come to that time for case decision. Okay, and again, we encourage questions in the chat box. Those that we can't get to today, we'll follow up with later. So the second piece, so once you've got a good intake and you've made a really good decision about what direction the case is going to go in, here's the other piece, is a good thorough assessment. What does that look like? How do we do? All right, and again, it starts with a timely and a thorough initiation. You're going to hear us ad infinitum all throughout this webinar, all throughout just the life of child welfare. Thorough initiations, getting out there timely, gathering as much information as you can, interviewing the children appropriately, right? Talking to all the people that are involved, you know, as much as you can find at initiation, because it is that information that you gather at initiation that prompts you to dig deeper, right? Hopefully, when you gather information when you gather information at initiation, you're not just stopping there. Hopefully that has put other questions in your mind. It has brought other people to your mind for collaterals. It has pointed you in a certain direction of things that you need to be doing, right? So a timely and a thorough initiation and a well-documented initiation, right? That is going to be key to making that case decision at the end, right? Then putting an appropriate safety assessment in place, right? And again, as we've talked about, safety assessments being behavior specific. You're not writing a case plan with a safety assessment. You're dealing with what's going on right now, right? What are the allegations? What is the safety issue that has to be addressed right now? And then what do you put in place? Because again, when you put a safety plan in place, you're saying to the family, what are you going to do right now? Right? What are you going to do right now to ensure the safety of this child? And then as an assessor, as an investigator, it's also pointing to you, what needs to be done to alleviate this safety issue? What's brought this safety issue to the forefront? What is going on, and how we're going to get to that place? Right? So a good, thorough, and appropriately filled out safety assessment is key. Again, is law enforcement involved? Hopefully, you know, you recognize the policy says we got to notify these folks. My encouragement is with law enforcement, don't wait until after initiation to involve them. You know, even if you notify them at intake, or if you're one who, when you first go out, I'd involve them as soon as possible, right? And so when you begin to work through the case itself, is law enforcement, because they're asking a different set of questions, they're coming from a different mindset, right? But you need to have them involved, and you guys need to be talking back and forth. I just want to throw this out. One of the things that I see when I review cases, At times when investigative assessments are being done for abuse, I rarely see much interaction documented between law enforcement and social services and child welfare, right? They're important partners, and we need to be documenting exactly what they're saying to us. Okay? So is law enforcement involved? Another thing, is there a need for, or was there a child medical exam or a forensic interview? You know, what does that doctor have to say? Are there allegations of physical abuse, sexual abuse, that there needs to be an examination, right? So that a medical professional that has the right letters at the end of their name is giving you not just an opinion, but a stated fact that, you know, this is child abuse, right? And let me just say too, when it comes to reading some of those reports, I understand that they're written in a different language than what social workers speak. And so we definitely encourage is that when you're working with those medical providers or with those interviewers who write those reports, ask them to give you a glossary of the kind of words that they use and why they say some of the things that they do. One of the things that you will see in like a CME report is they may make a statement, and I saw this recently in one that I looked at. They may make a statement that says, you know, there is no medical reason for this child's injuries. But then the follow-up statement is that the diagnosis is child abuse. Right? So when you combine those statements together, the doctor is saying to you, there's no medical reason that would rule this out. And so yes, child abuse is the result of what we're saying. Right? And you shouldn't separate those two out. And sometimes that's confusing because I saw someone that they unsubstantiated because of the first statement. Right? So when you're working with those medical folks, ask them, what do you actually mean by that? How are we talking about that? All right, so that I can make the best case decision when the time comes. All right. Also, thorough collaterals. Who do you need to talk to? And again, not just, we want to get the ones from the family. Who are those folks that support them that will give us a bird's eye view of who they are? But also in the initiation phase or even from the report itself, who are other people that have eyes on this family or that touch this family in some way? Right? And what information can they provide to give us an understanding of what are the dynamics when those doors are closed? What are the dynamics of the way these parents interact with their children? How are these children acting when they're in school? What types of behaviors are we seeing, right? And thoroughly documenting those so that as you're moving along, your mind is beginning to move towards, am I substantiating? Am I not? Those types of things, okay? So thorough collaterals are extremely important. And a good risk assessment, you know, please make sure you're filling that out appropriately. Not only looking at the current circumstances, but there's questions on there about previous history. And again, I recognize we don't want to use previous history in a punitive way necessarily, but previous history can give us an understanding, right, of the dynamic of why is this parent acting this way? If there's history there, has that been dealt with? Doesn't necessarily resolve them from things they've perpetrated on their child or other children, but it gives us an understanding. It can push us towards making that case decision. So using the risk assessment appropriately and making sure everything is filled out thoroughly as we do it, okay? And then supervision. Cannot say this one enough. Supervision is key, right? Not just regurgitating the facts of the case. Talk to a person and this is what they said, okay, now go talk to this person. But you know, one of the things we really want to see is that very soon, a week, 14 days at max, into talking about that case, right? What are some next steps? Where are you headed? What do you see that this case is headed towards? Right? You know, the example I love to use around supervision is most of us, when we worked in the field, we potentially had to place a child in like a PRTF or some type of facility like that. Right? And you know that you'd get that child placed and within 12 or 24 hours, a social worker from that hospital is calling you and saying, what is the discharge plan? Right? So what is the plan for when this child gets out of here? I also believe the same applies to supervision. Now, I'm not saying that you move a case too fast, right? But supervisors need to be asking early on in the case, what are the closing questions? Have you talked to collaterals? What do those collaterals say? Asking the social worker, what do you sense is going on? Do you think we're moving towards substantiation? Do you think we're moving towards services needed? Do we need to engage? Do you feel like we might potentially need to talk about engaging the court? Right? Supervisors drive all of those things, right? And they can also make sure that by the time you get to case decision, there's good information there so that they can move the case decision to the right place, right? And I was so excited this morning when I saw the breakdown that there was, I think, supervisors made up probably the largest group of folks that were here, right? And so supervisors, yes, we put a lot of onus on you. Don't just hear the facts of the case, but then asking the closing questions. Where are we going with this? Right? What decision are we headed towards? And why do you think that way? What is it that you've seen in the interviews or the information you've gathered from law enforcement or from the medical exam? Why do you think we're headed that way? So that you can begin to make some of those plans. All right, so a thorough assessment is an absolute must. So the next step, and this is where I think a lot of folks get tripped up, right? Because we want to move next into case decision. Let me just say that when it comes to deciding, particularly when you've got an abuse case, there's two steps we want you to take. The case decision process can be divided into two parts, right? The first one is you need to answer the question, what is the status of the child? Okay? In other words, the allegation came in, this child had unexplained physical injuries. Was this child abused? Right? Is the child abused or is the child neglected? Right? What info do you have that supports this? Right? What SDM tools show? What that risk assessment, that family strengths and needs show? What are the answers, thorough answers to the 4 questions at the end of the 50-10? Okay? The reason is that that's the first part you got to make. That's the first decision you have to make. With the information in front of you, do you have enough that says, yes, this child was abused? So in other words, did that medical exam say this is child abuse? There's no medical reason this child should have this injury. There's no practical reason this child should have this injury. Right? There's no practical reason that this child should be acting this way. There's no practical reason or no medical reason that this child should be exhibiting these symptoms of this kind of behavior, right? So you have to first decide what is the status of the child, because when you go to do the data entry piece, that's what it's going to ask you first, right? What is the status of the child? Are they abused and are they neglected? And this is why I go back to it's so important for that thorough intake and that thorough assessment so that you can answer the question, what information do you have in front of you to support this? And as much as I trust a social worker's gut, as a supervisor, I'm going to say, yeah, I hear what you're saying. Now help me back this up. Do we have a medical exam? Do we have a forensic interview? What are collaterals saying about this? Right? What information do we have that points us to making that decision that, yes, this child is abused or neglected? Okay? That's your first step, right? And please hear me saying these need to be decided independently. So once you've decided, if you make this in step 1, if you decide that the status of the child is yes, there's clear information that this child has been abused and or neglected, step 2, is there a clear perpetrator? Here's where I know we get tripped up a lot. We come to this place at the end of an abuse case and we begin to think about making the case decision based on step 2. Do I have a perpetrator? Am I going to have to put that person on the RIL? Right? I can't sub if I don't have a perpetrator. Not true. Please make sure you understand the difference. Right? Is there a clear perpetrator? In other words, and again, what info do you have that supports this? What doubts do you have about this? And I'm going to let Gail step in a little bit here too, because this is an excellent place to potentially involve your agency attorney. Right?
Right. So, you know, when I worked in the county, I took for granted that and just assumed because of the way we did things, and I worked in 2 different counties, that cases are always staffed with an attorney. And I realize that some of you may not have the kind of access to an attorney that counties with embedded staff attorneys have. But I would encourage you to still staff your decisions about the RIL with your attorney. Especially the ones where you're really not sure about the perpetrator. So, and those are really the hardest cases. So one way of thinking about it is that the perpetrator isn't always the person who actually inflicted the harm. Sometimes it includes the person who allowed it to happen. So if you look at the definition of abuse, it could be someone who inflicts or allows to be inflicted harm to the child. So staff it with your attorney because, you know, they know the law. They're the ones that if there's a petition filed for judicial review, they're going to have to defend the decision. And then, yeah, so
Well,
I
and then
have
I
more
think
to say about that, but I think it's the next slide. So
it is, yeah, because I was going
yeah,
to go on that. You know, there is serious neglect, and so I'll turn that back over to Gail too.
right. So think about serious neglect. It's not about a child. A child isn't seriously neglected. In North Carolina, a child is either abused, neglected, or dependent. So serious neglect has this own special little spot in our statutes, and it only refers to the RIL. So serious neglect, I'm going to go ahead and read this to you, is conduct, behavior, or inaction of the juvenile's parent, guardian, custodian, or caretaker that evidences a disregard of the consequences of such magnitude that the conduct, behavior, or inaction constitutes an unequivocal danger to the juvenile's health, welfare, or safety, but does not constitute abuse. So let's take a scenario where you have a child who is clearly abused, and the two parents were the only people exercising care and control of the juvenile during the time the juvenile was injured. Even if you do not know which one inflicted the harm, whichever one did, the other one is either covering it up, lying, or demonstrating an inability or unwillingness to protect. I'm not saying that in every single case the non-offending, there's never a non-offending parent. I'm just saying it in situations where you have a child who has been injured, the injury has been inflicted, and both parents are saying, well, we don't know, you know, oh, he fell off his changing table. Yeah, that's it. No, probably not. So you have one who has abused and one who has seriously neglected. And just because you don't necessarily know which one did what, you probably have a pretty good inclination based on your interviews and your assessment of what actually happened. So, so you should be able to, in most cases. It gets, of course, it gets way more complicated if you've got like 6 people who could have potentially injured the child. And that gets really confusing. And again, staff it with your attorney. And then one last word on serious neglect. Think of it this way, and hopefully it'll be helpful. A child is abused, neglected, or dependent, but a caretaker can be seriously neglectful. So children are not seriously neglected, but caretakers can be seriously neglectful, if that makes sense, which I hope it does. And if it doesn't, you know, we'll have questions at the end of this.
Right. Thank you, Gail. You know, so again, just as a reminder that, you know, when you come to the end of the case, when you're at a point of making case decision, please, you know, be clear about the 2 steps. Focus first on the status of the child, the information that you have in front of you. Does it show that the child is abused or neglected? And then determine, do I have a clear perpetrator? And it's a good place to involve your attorney. So, Laura, I wasn't sure if I was turning this one back over to you or not, but we're going to take a little kind of a break here and say I haven't seen any questions in the chat box, but
All right, so anybody who has questions at this point, you can go ahead and type those into the chat pod. So far we don't have any, so I'll just take a minute and let y'all have a sec to see if you have any questions at this point.
I just did that.
Renee's question, are you going to cover when there's not a clear perpetrator? Yes, and that becomes part of the data entry piece, what you can do, because it potentially should not affect your case decision. Okay?
So,
and Travis, we're going to talk about that piece. Go ahead, Gail.
oh, I was just going to say, you substantiate, you know, abuse. A child can be abused without there being a clear perpetrator, because the substantiation is about the status of the child, not necessarily who harmed the child.
Okay. Yeah, I think they'd want maybe a little bit more of discussion about the seriously neglected piece.
Right. So, what else can I say? I know it's confusing. I didn't write the law, so because because there were cases where I remember back in the day, people, agencies or counties alleged children to be seriously neglected, and it went up to the Court of Appeals, and the Court of Appeals knocked it down, saying there's no such thing. So children aren't seriously neglected. It's the caretaker, parent, guardian, custodian. So, you know, in my mind, the example I gave is an excellent example. So, you know, let's say you've got a situation where dad has abused a child and mom is basically covering it up. Well, she didn't actually harm the child, but she allowed that to happen. That would be, in my mind, and Peter, you can jump in if you want, but to me, that would be the sort of thing where I would want to put both of them on the RAL, one for abuse and one for serious neglect.
Yes. And I think that addresses Stephanie's question. For clarification, under serious neglect, does the parent also get placed on the RAL? So yes, if you determine that that parent seriously neglected the child, then you would place them on the RAL. Just back to a couple other questions I see there. When there's not a clear, that's why I wanted you to hear the difference, the two-step process, right? Because the first thing you're doing is you're deciding, is the child abused or neglected, right? You can substantiate for abuse and you can substantiate for neglect, and then on the 5104 you can say no clear perpetrator, that you are not able to identify a perpetrator, right? So again, that's why we need to make sure that we're separating those two things out when we're getting to the end of these cases, right? So again, talking up front as social workers with your supervisor, program managers, even directors if you need to that place where, is this child abused? And if you've got clear evidence that the child is abused, a doctor has said so, forensic interview has clearly identified, whatever it may be, right? And then you get to the question of, is there a clear perpetrator? You know, a lot of times, like Gail pointed out, sometimes over the course of a couple of hours, 15 different people had access to this child. And it would genuinely be difficult to say, right, who the clear perpetrator is, right? And again, as we suggested and encouraged to do, at that point you would want to bring in your agency attorney. Here's the people that we see, here's the information that we have, you know, so you can say there is no perpetrator but still substantiate the case. Okay? And someone asked about, go ahead, Gail. Yeah.
Oh, were you going to say the same? Child perpetrators? No, yeah, they
go
don't.
Ahead, tell us about that.
Yeah, you can't put them on the RAL because a child, by definition, can't be a caretaker. Right. It's an adult.
Right. And you also have to clearly understand too, and this is why I go back to looking at the entire process from the start. All right. Typically in policy, child on child is not accepted as an investigative assessment. That typically is accepted as family assessment supervision. Okay, unless the supervision is severe, it could be neglect that they haven't appropriately supervised. It could come in as an investigative assessment under neglect, but typically when it's child on child perpetrators, you're looking more at a supervision issue with the parents.
So someone, Cynthia, is asking, when would I know when to involve the attorney? I personally, well, you're going to have to ask your director, but I believe that a case or any decision about this should be staffed with your attorney, just like if you're going to file a petition. And I know that isn't always done, but this is the sort of thing that, you know, you wouldn't find yourself making an RAL decision at 2 o'clock in the morning when you're, you know, don't have access to your attorney. You know, at some point during the day, you're going to have access to an attorney. And my thought would be that before you're going to put somebody on the RAL, you should staff it with your attorney.
And Shannon's question, we recognize that that is an issue right now with an NC FAST, and that's being taken care of. They're supposed to be working on through that, so that if there are pending criminal convictions, there will come a time, yes, we'll be able to change that. So Shannon, we hear that question regularly, so and NC FAST is aware, and we're working to get that resolved.
Child
Jamie,
parents
I see it.
are still children, so yeah. No, they don't go on the RAL.
Okay, let's see. I'm just looking to see if we've missed anything.
Travis,
What
when
if the
there is no
children?
clear perpetrator, you mark such on the 5104 and you're not serving anybody. The only time you would get, and we'll get to service in a little bit, the only time you would be serving someone is if you have clearly identified a perpetrator.
And again, your attorney can help you,
Mm-hmm.
I would think, try and figure that out if you're not sure.
Gail, I'll let you take that one from Henderson County. That's an interesting question.
Child-on-child sex abuse and the care. Ooh, caretaker continues to allow access. I think, yeah. But yeah, I'm going to sound like a broken record. Staff it with your attorney. I'm sorry, but I possibly, yes, possibly.
Right. And this is one of the reasons too we wanted to do something like this, because yes, there aren't always clear-cut answers. I mean, we could easily say, well, yes, if that happens, put everybody on the RL. But again, what are the circumstances of the case? What's been going on? What did the parents know? What did they not know? What did they try? Those types of things. And so again, that's why we're genuinely encouraging partnering with your agency attorney to go through all that, because those are tough cases. We recognize. Again, as I said at the beginning, it's easy to say RL is easy until you get to a case like that, right? Okay, so we understand. Okay, Laura, do you want to go ahead and move on? And
Sure, I can see John's tracking all the questions and answers right now in our notes pod, so that we'll be able to capture that. Anything else that comes up, please go ahead and type it into the chat pod, and we'll capture it for our next round of questions.
And we will try to answer as many as we can today, at least as appropriate. But we'll also do some follow-up afterwards. All right, the questions, because if there's specific ones that we need other guidance on, either from the AG or maybe from our policy folks. So there will be potentially a follow-up document as to answer some of the questions.
Okay,
right, Gail,
this is the fun part. So it's not optional. If you've substantiated abuse, serious neglect, and you've identified a perpetrator, you have to go through the RAL process. It's not discretionary. 7B311 requires the Department of Health and Human Services to maintain a list of responsible individuals. And if you actually are so bored you want to read statute, it actually says the word shall. So whenever you see the word shall in a statute, that is a red flag. That means this is not optional, you must. And then 7B320, after the completion of an investigative assessment response that results in a determination of abuse or serious neglect and the identification of a responsible individual, the director shall personally deliver written notice of the determination to the identified individual in an expeditious manner. So the way that's worded is a little confusing, because if you read that, you'd think, oh, so a child can be seriously neglected? No, they're using the word determination rather than substantiation. So again, don't get those things confused. You don't have serious neglect unless you've got the identification of a responsible individual. So yeah, this slide is merely to let you know that you have to do it. Next slide. Yeah, there it is. So expeditiously, that was changed this past October because folks were getting hung up on the 5-day thing. And what we wanted to do was purposely make it vague, so that there wasn't a specific time frame. The department, you guys won't be hemmed in by, oh God, we need to do this within 5 days. But you do need to do it expeditiously. And really all that means is you can't dally. And you've got to make your efforts. And so the important thing here is, as you all know, if you didn't write it down, it didn't happen. So make your efforts and document, document, document. Because if a person, a responsible individual, files a petition for judicial review and they say to the judge, oh, they took too long to notify me. Well, then your documentation is going to prove whether or not you notified them in an expeditious manner, and that will be up to the judge to determine whether or not he or she believes that you did it expeditiously. There was recently a Court of Appeals decision that came down, don't remember the county, but basically reversed an RIL decision because it was found that the county violated the parent or the responsible individual's due process by waiting too long. That was before the law changed. So, and in anticipation of that decision, that's why the law changed. So, you need to provide personal written notice, and the notification has to happen within 5 days, of your case decision. And then you've got to provide the written notice within 15 days. And the notice has to be sent by registered or certified mail, return receipt requested, and address to the individual at the individual's last known address. Again, here's the place where you need to talk to your attorney if you are not sure how to locate this person, how to get them served. And yeah, I think that's it. Anything I missed there, Peter? And it's not actually the same thing as service. I'm sorry, when we say service in a legal sense, it's a notification. So, the social worker handing the person the RIL letter, that's a notification. That's considered a good notification. So, and then of course document. When I find the perpetrator, I think the next one's still me. Yes.
Mm-hmm.
I think there is a form letter or a sample letter that the division has that is good to use, so go ahead and use it. But make sure you're detailed enough when you're filling out the part about why the assessment, why it was substantiated, and why they were identified as the responsible individual. I'm not suggesting you cut and paste your entire case decision or narrative into the letter. A couple paragraphs, you just have to put them on notice about why you made the decision that you made. And then of course the letter has to be clear about their right to appeal and the steps they can take to appeal. And we recommend getting a signed statement of receipt. Sometimes they don't want to do that, and that's fine. You can note that they refuse to sign and then move on. That's it.
You got one more.
Yes. So after, if a person files a petition for judicial review, the director is required, again, not optional, the director must look at the evidence and determine whether or not there's sufficient evidence to support the determination that the individual abused or seriously neglected a juvenile and is responsible. This doesn't mean the director has to reverse the case decision. Of course, the director can. If the director looks at the whole case and says, this isn't good, I'm reversing it, yeah, but it is not required. So the case decision theoretically may stand, but the director might say, I don't think you have sufficient evidence to have identified this person as the responsible individual. And so we're not going to go forward. And then basically what happens after that is the director has to notify the individual in writing. You can't put that person's name on the RIL. You need to let your attorney know because the copy of that letter should be filed with the court so the court knows that that RIL proceeding is not going to go forward. It just kind of stops everything in its tracks right there. We have heard that during the course of some RIL hearings that judges have been ordering directors to reverse their case decision. which is problematic, and there's some debate as to whether or not a judge can do that legally. So let us know if that happens. It's a little concerning.
Yeah, I've
Is
seen
this
lots
more
of questions pop up here.
Oh, Lordy.
Yeah.
Yep.
I wasn't
I
looking
did
at
want
it,
to, before
so.
Gail that's okay. I did want to address one that seems to be a little bit of a pattern. We recognize from the division that in the world we're living in today, more and more minors are having children that are becoming involved as parents with child welfare. So we understand that. And agencies struggle with, do I make them the head of the file? Do I use their parents and that kind of thing? I think, and Gail can address the RL piece, but I think, moving forward, we are having discussions about what type of policy or either guidance or guidance we can put in place. I don't want to give a blanket answer today, except just to say, if you're struggling with that, again, please give us a call and let us kind of help you process through what are the circumstances, what are those things that are happening in the life of that family, that type of thing. But, so please don't be afraid to reach out. And Gail, one of the questions that came up was, again, just could you place that minor child on the RIL if they did perp on their child?
No, it's for adults only. And if I can go back, because I kind of feel like I may not have explained this in that expeditions thing you've got 5 days. In the old, before the law was changed, you had 5 days from your case decision to notify the individual. Now it's expeditious. So the registered certified mail return receipt thing happens if you can't notice them within 15 days. So, you try, and then within, if you're coming up on 14 days, then go ahead and send the registered certified mail at the last known address. And then right. It's just that, you can't wait months anymore. Any update? A petition in Spanish, Peter?
I think the judicial review one's isn't that an AOC
Calendar
form?
days. Sorry. Go ahead.
Okay. Yeah, calendar days on that question, but isn't the
Yeah.
review form an AOC form? If not, I mean, we can look at, the division is working on translating as many as we can. It just, a lot of it is a resource issue with just manpower to get it done. So we're working on that. So yes, and if it is an AOC form, thank you, Caitlin, then we'll have to get with our partners at the AOC to see what the progress is on that.
Shannon, yes, if the PERP refuses, you leave the letter with them and document the refusal. Can you define expeditious in your policies? I wouldn't, because at the end of the day, that's going to be up to a judge to decide if that judge thinks you were expeditious or not. So, but that's more of a Peter question
Yeah.
than a Gail
Well,
question.
we would want to see diligent efforts documented before you tried to encounter a judge. And Shannon, yes, if the PERP refuses to sign, Gail had said that you can leave it with them and document that you did make contact, you left it with them, they refused to sign. Okay.
If your diligent efforts are not successful and later, I'm sorry, it's hard to read the questions because whenever there's a new one, it scrolls and then I can't.
Yeah.
And now I lost it. Where is it? Oh, are not successful and later on 6 months, the PERP is in the home, can you serve the notice then? That's Travis's question. Travis, I would have within 15 days sent it to the last known address. Return receipt and all of that. Now, if they weren't there, then you would have within 6 months. 6 months is a long time. So let's say you couldn't find the person, you sent it to their last known address, and the return comes back not signed, right? The return comes back saying this person's not here. At that point, your attorney should be petitioning the court to proceed with the RIL and show a judge that you made diligent efforts to locate the person. and then sort of get judicial permission to put that person on the RAL. So you should have that resolved way before 6 months passes and the guy shows up again.
So John, I know you've been tracking the questions. Are there anything that have been coming up sort of multiple times or similar questions that we should make sure we're catching?
I'm not sure. I've been it's been a little
Sorry, I'm having internet
the answers
problems.
and
Okay,
Yeah.
let me
Well,
just
why
take
don't
a
we,
second.
yeah, why don't we,
Look.
yeah.
Yeah, that's a great idea, Peter. You can continue on. We'll scan the list and we'll have them at the end.
And again, you guys, thank you. We understand, and this is why we wanted to do this. The more questions we can have that we can aggregate together, you know, just to be sure that we're answering your questions best we can. And again, go ahead, Gail.
Oh, I just, that question that I answered before, I just want to elaborate on it a little bit because it's important. And I'm reading from the statute here. If the director cannot show that the individual has received actual notice, the director shall not place the individual on the list until an ex parte hearing is held in which a district court judge determines that the director made diligent efforts to find the individual. So if you're having a problem finding this person and you go ahead and you send out that certified mail thing and it comes back, this guy isn't here or whatever, or it's signed by somebody who isn't that person, go to your attorney. Your attorney should facilitate this, petitioning or motioning for an ex parte hearing so that you can get permission to go forward and place this person on the RAL. But until you do that, you cannot place the person on the RAL. And somebody's asking if it's delivered 2 months later. It shouldn't be. You've got to do this all like within 15 days. If you don't, you've got to send it out there, return receipt. And you will get a notification at some point or another that it was delivered or not. I've never heard of it coming 2 months later. If that actually happened to you, Jeanette, I would say staff with your attorney because that's a new one.
Okay. All right. In the essence of time, there's a few more slides we want to get to about the data entry piece, but keep asking the questions. And again, we will be compiling these and sending out some follow-up guidance as we put them all together. Again, recognizing too, you've probably got specific questions about the process, about the legal process. And so keep asking them and we will get the AGs involved as well to get as much information out to you guys as possible. So again, we recognize, I can just tell, this is just verifying why we needed to do this. So there's lots of questions about how this takes place, and we want to make sure that you guys are all comfortable at the kind of level about how you're doing that. So let's talk a little bit. I just want to talk a little bit at kind of a high level about data entry with Legacy and with NC-FAST, because one of the things we have seen is that some folks don't always follow up with getting it in NC-FAST and on the Legacy system. So just a couple of things to keep in mind, right? Several of you asked about if there is no perpetrator. Well, on 5104, you'd enter 00 in field 23, and in field 31, you enter 05, and I'll show you a picture of that. And all of these are located, all these codes and what they mean are in the manual, in that place where I showed you about the data entry pieces. So you can see that 00 indicates to the system there is not a perpetrator, 05 indicates there is not a perpetrator, right? Now, if there is, in field 23, you have that relationship code. Could be 1 something or 2 something based on their gender, okay? Then you fill out, if there is a clear perpetrator, you fill out fields 33 through 40. 39 is automatically 00 until the 5104A is completed. And that will be automatically updated when you complete the 5104A, right? So again, if you've got a clear perpetrator, right, fill out these fields, right? And here's a picture of what that looks like. Right. Here's field 23 with the perp relationship, the finding reasons in field 31, right? And so then if you do have a clear perp identified, you're filling out, let me get my little pointer here, they showed me how to do this. right? You're filling out these sections here, okay? And again, 39 right here will automatically populate with a 00 until you complete the 5104A, all right? So again, I refer you back to the manual to look at those codes, because again, if you don't have a clear perpetrator, it's 00 here, and then it's a 5 here, and that will tell the system that you have substantiated for abuse, but you have not been able to identify a clear perpetrator, and so nothing else will be required down here. Okay? Now, for the 5104A, a couple of things to keep in mind as you do the 5104A. Do not attempt to complete it until the decision about the RIL is final. Not your case decision, but your decision about the RIL is final. Final means you've clearly said that someone's been served, time has passed that they have not filed notice for appeal, or perpetrator filed an appeal, it was heard, the court rendered a decision about whether or not the person would be placed on the RIL. Okay? Or perpetrator has been criminally convicted prior to case decision. Now that's rare, but sometimes it can happen. Right? So if one of those three things are in place, 15 days or so has passed since you served the individual, you've not been given any notice of appeal, complete the 5104A. Perpetrator filed an appeal, you went to court, the judge says yes, it's appropriate, there's enough information to show that they are the perpetrator, place them on the RIL. Or perpetrator has been criminally convicted prior to case decision. Okay? So here's what the 5104A looks like. All right, again, here's where you're filling in the date for the notice of appeal. Sorry, let me get my little pointer. The date for the notice of appeal. All right. Then the other decisions are filled in based on what happens. All right, around here. This one is no longer in use. All right. But again, this indicates here, and again, and the thing I want you to hear, and I'm going to go back right here. Okay. Because we had this come up yesterday with the county. The second one that's there, the perpetrator files an appeal and it was heard. The court rendered a decision. If the court did not agree with social services that the perpetrator was clear, you'll indicate that on the 5104A, that the court said no, so the person does not go on the RIL. It does not, much like the director's review that Gail talked about, it does not affect your case decision. You have an agency, you have still decided and said that this child was abused. The court has said, we don't have enough information for a clear perpetrator. Again, that's why I go back to that process at case decision at the end, two separate steps. Yes, the child is abused. Yes or no, there is a clear perpetrator. And in this particular case, the court has made that decision for you. They have said, no, we don't, the court does not believe that there's enough information at that point to render putting this person on the RIL. Right, and so you would indicate that on the 5104A and the person would not be put on the RIL. Okay. All right. The second part is about NC-FAST, and I'm not going to walk through and show you how to do NC-FAST, but I just want to, much like we did with the 5104A, I just want to show you some things about what happens those counties who are using NC-FAST for your investigations. When a maltreatment of abuse or serious neglect is substantiated, you can see NC-FAST automatically places the alleged perpetrator on the recommendation list. And so when you pull that, when you look at it on the screen, or if you pull that report, the status would be in progress, unless the individual is unknown. Please understand, just because the system has done that, it does not place the person on the RL. It simply starts the NC-FAST process. Right? There are still steps the agency has to take. Again, either waiting on notice to be given to the individual, waiting on them to file a notice of appeal, that type of thing. Right? So whatever it is, just be reminded, it starts the process. Right? If a supervisor approves the case decision, it enables a personal written notice tab for the worker. Right? So in other words, you can go in there and a tab will come up and you can create the personal written notice. If you don't approve it, the supervisor can either cancel it or send it back. Okay. Second part about NC-FAST, the RL recommendation cannot be disposed or finished in NC-FAST until 16 days after the delivery. So in other words, it's saying to you, if you've notified the person on this day, 16 days later, the system will open up to allow you to finish the RL process. Right? Only a supervisor or above can dispose of an RL recommendation. So if the worker made a recommendation within their case to put this person on the RL, 16 days has passed, only a supervisor can approve or above can approve that recommendation. Okay? An individual will not appear on the RL until the supervisor completes the step. Okay? Now, if a petition was not filed, like if the person didn't file for a petition for review to look at it, the task for disposing the RL recommendation is generated in CFAST on the 16th day after delivery. All right, so if you've not gone in and indicated that the person filed a notice for judicial review, then a task will be created reminding you to go in and do so. Okay? I understand, we do know that there are issues with some of what's going on within CFAST, and we're working diligently with them to get those corrected. And I would encourage, putting in a help desk ticket, right, and working with your liaison to help get that resolved, right? Just a couple of reminders about NCFAST and the RL. When you are searching for individuals placed on RL, please remember to search both. We have approximately a little over 20 counties that are in NCFAST using the RL. Those will not appear in the legacy search. So you need to look in legacy and you need to look in NCFAST. Right? The other part is, and this is just, there are additional steps for updating the RL, like after director's review, after judicial review. The job aid has been updated recently to talk about this process. There's where it's located, and it's called Responsible Individuals List Complete Process, Recommendation, Appeal Rights, and Final Determination. So I just encourage you, go there, use that. And again, if you have issues with the NCFAST, you may have to do a help desk ticket. Let them know. They can help walk you through the process. Okay. So some questions. I'm going to look at Stacy's first because that's the last one. So if I put someone on the RL and NCFAST, also, no, you don't do it in the legacy. You're doing both. That's why we're telling folks look at both systems. So like when the NCFAST process is complete, they are considered on the RIL, and people will need to look for both.
So Peter, I'm scrolling up to the top of the questions that we don't have answers for yet. So the first one is,
we'll do the best we can.
Alicia, can you see that? Alicia says if someone else signs for the certified mail, hold on, I'm going to scroll over. Can we proceed?
Gail, what do you think?
Oh, God, broken record, staff with your attorney, because honestly, it's going to depend on your judge, and it's going to depend on who that person was. If your perp was, if your perp lived with his or her mother routinely for years and years, and mom signed well, even then, it's going to come down to whether the judge thinks that it was sufficient, and one of the things that's actually in the statute is evidence of the person evading services is considered or notice is considered relevant. So, if you've got proof along with that they're avoiding service or notice, that might help you. But I would say in most cases that's probably not going to be sufficient. Someone else's name.
Okay, John's tracking that. Then we have
here's it. I see the one from Kizzy. I think that's an interesting
ahead, Peter.
question. How do you place a human trafficking perp on the RL if they only go by street name, nickname, and don't have a legal name? I think even law enforcement deals with that pretty regularly. What do you think,
I
Gail?
don't know how you can. I don't know how you can if you don't have the person's actual name.
Right.
Yeah.
Yeah. It may take some more digging on your part, but yeah.
Right. I mean, I'm working with law enforcement because they may know who the person really is.
Travis asks, what if your agency attorney advises against the ex parte hearing for placement?
I don't know why they would do that, but there may have reasons. It's too, I mean, if they're advising against that across the board, you might want to ask why. I mean, is it that you think our documentation of diligent efforts is insufficient? Because maybe it's something you can fix. I mean, I'm not sure why an attorney would advise that, or if it's just case specific. I saw something interesting about what if the agency court process that an RIL hearing cannot take place until after there has been a criminal conviction. That should never happen. That should not be happening. Who asked that question?
Travis.
Travis. Yeah. So you can't wait. Now, well, let me go back. So yeah, I would say in probably 100% of the cases I had in the RIL, if there was pending criminal charges, we just put it off. We just put off the RIL until after the criminal charges were resolved. So now I have heard of judges putting off adjudications in those situations, which is absolutely terrible and should never ever happen. But there are reasons that have to do with due process for the perpetrator, and I don't. Now, Peter, there may be policy or other issues with waiting for that, but I think most judges are routinely going to order that the RIL hearing just gets stayed until after the resolution of the criminal charges.
Right. Yeah, I'm not aware of any necessary policy implications beyond just getting someone on the RIL. But if the delay is legitimate, then it's legitimate. You know.
Yeah, I would say, I mean, to be honest, it does say in statute that the court may postpone or stay, which is the same thing, an RIL hearing in waiting for the results of the criminal hearing. So it says may, but if personally, like if I were the attorney for that person in criminal court, there's no way I would want that RIL hearing to go forward until after the criminal hearing, because the perpetrator has a lot more protections and the standard of proof is a lot higher, you know, in the criminal hearing.
All right, so the questions we have left that have not been answered are over there on the right. So the first one is the ex parte hearing information entered in the judicial record, I think it says?
In the review, I think she's about on the
5104,
5104A. No, there's not a place for this. It's just that the ex parte is just another step, Renee, that the agency can take to show notification. So that what you're waiting for at that point to fill in is when the perp was actually notified at that point. So, so there's not a place for that ex parte hearing to take place. Can someone be subbed on and not put on the RL? If you've subbed abuse on a child and you have a clear perpetrator, then yes, they must go on the RIL and go through the process. Now again, the reasons they would not, if your director reviews it afterwards and says, no, there's not information, they don't go on the RIL. A judge looks at it and says, no, you don't have enough information, then you don't put them on the RIL. But as an agency, you can't make that decision prior to that. If you've substantiated on someone, you need to either clearly identify the perpetrator or not. Okay. And Lindsay, you asked a good follow-up question about perpetrators being out of state. As a matter of fact, several of us, including Gail and Andrew, had some very good discussions about this. So, and policy kind of lays out, especially if it happens in North Carolina. You know, if it happened out of state, and the child's here and we're somehow involved, I don't know that we can do it if it happened out of state, but the question really came up for us, like, and we run into this, I think, especially in those vacationing counties, mountains, beaches, places where people come just for a short period of time, you know, because North Carolina policy says if the other state won't accept it, then we finish the assessment here because it happened in our jurisdiction. And I think Gail and Andrew had some interesting thoughts about, even if the perp lives out of state, could we follow through with the process here? Gail, you want to throw anything in on that? Because I don't know that we necessarily resolved anything.
Sorry, I muted myself.
That's good.
I don't think it matters, honestly, if they're out of state. If they, if the investigative assessment happened here and the county here found them to be responsible, then I do not believe it matters where they live. It may, of course, present some challenges with notice, but I think that's where we came down on that, and that was just a sort of an interpretation based on reading the statute. I don't think that has come up in a Court of Appeals case or anything like that.
Because our policy does say if the offense happened in North Carolina and we substantiate it here, we should go through the RL process. So, Daphne, answer your question. If counties are having specific issues around the 5104, let us know, and we can try to help resolve it as best we can from here. If not, we can put you in touch with the legacy folks to see what's happening with that. Renee asked a follow-up question, so we just document the date that it was ordered. Yes, because that's potentially something you would need to share with the judge. You know, say, Your Honor, like if, so yes, just document the date that you had that ex parte hearing.
So we have a question about attorneys being users on NCSW Learn. I don't know the answer to that.
I don't know the answer to that either.
But I can find out.
That's a good question. We could certainly see, because I think
oh, I see. To view this webinar, I'm reading the whole thing. I have to scroll over.
Right.
So yes, they
Okay.
can go onto the FCRP website and be able to see archived webinars there. That's open to the public. So we'll make sure it's in this PowerPoint in the beginning, and it's also down there. John just put it in the chat pod. So that's how you
Right.
could access this information later.
Right.
And then Wayne, there's a question about Wayne County.
Yeah, I answered that one. That's the one.
Okay.
If they're having specific issues about fields populating, we'll need to work with our
Deal with
legacy
that,
folks
okay.
to address that.
Just trying to make sure we got them all. Did you get this one about Stacy? Am I correct that they file a petition? You see that, Peter?
Yes, if they file a petition for judicial review, and we're waiting on a hearing, you cannot complete that process in NC Fast.
Let's see.
Bridget, that's a good question. Does the ex parte hearing date become the service date when completing 5104A? Haven't been hit with that one yet. Let me think about that one, Bridget. I think that's a good question. I think that's something, let us follow up with that and be part of the document follow-up document that we'll send out, because I think that's worthy of some other discussion too. So thank you for that.
It looks like we have one more question there from Takesha, which is a case-specific question. So how would you like them to handle that? Oh, are you guys hearing me?
Yeah, I'm
Oh, there we
looking.
go.
I'm looking at it.
That's okay. I'm sorry. I'm having an internet
Gail,
delay,
can you see
so
that
just
one?
want to make sure.
Can you see that one?
Is it the question, we
So
have a case where the RAL involved 3 children?
Right.
That one?
Yeah. I think as long as it's the same perpetrator on all 3 children.
On the child? Yeah,
So apparently criminal charges were only based on it looks like criminal charges are maybe only filed based on what happened with one child, not necessarily all 3 children.
Right. Well, you've only got one responsible individual, so right. You wouldn't. That is a tough question.
Right.
Geez, you guys keep coming up with stuff that I never thought of.
Takesha, I tell you what, that is kind of case specific. And that's why. So Takesha, let me just encourage you to reach out to whoever your consultant is with some details, and then we'll get Gail and Andrew involved. Maybe with your attorney.
And your attorney, because that's a really interesting question. Right. I have to let that one marinate a little bit.
So you guys let me tell you, this is why I love county folks, because you guys deal with this stuff every single day, and I love that, and I appreciate that, and this is why we want to do stuff like this, is to I don't know how easy we necessarily make it, but we want your job to go as smoothly as it possibly can. So had the
All right.
state thought about changing the name of the list, I have a parent. He misunderstood the title. Okay. I don't know. We could look into something like that. So, but go ahead, Laura. I'm sorry. But again,
That's
let
all
me
right.
just say as we wrap up, I just want to say that I genuinely, we have recognized the need for something like this, and we recognize too it's not going away. Please understand that just because we do a webinar, we're not going to quit talking about it. Please know that as consultants, as folks from the AG's office, I'm going to go ahead and throw Gail and Andrew under the bus too. Whatever questions you have like this, please don't hesitate to reach out, especially with case-specific ones. We want to help you get to the best case decision and making sure that the appropriate people that need to be on the RIL are there, so that children are protected in the future too. So go ahead, Gail.
Yeah, but in terms of reaching out to us, have your attorney do that, because we can't really, you guys have attorneys and it's not actually, we're not your attorneys, and so we can't really give you legal advice directly. Sort of a weird dynamic, but trust me, just have your attorney reach out to us.
Yeah, the one of the things I've learned, and it's appropriate, is that from the AG's office, they prefer to talk, and it's appropriate, attorney to attorney. Right, so let make sure you do that. Go ahead, Laura. We'll let you have it back.
No problem. It's just we want to, as we wrap up, we want to ask y'all to think about one thing that you will do differently or do now in response to what you have learned today. And we'll just let you guys have a minute to type.
And I'm going to go ahead and say while y'all type, here's one thing that I would love to know is taking place in agencies with this, that a webinar like this would be part of an onboarding process, so that when new staff come on, this is part of what they're doing as you're onboarding them to get them prepared. So that's just my soapbox this last few minutes.
All right, so just looking at the chat pod, we're seeing it's going really fast. Review policy, talk with agency attorneys, check NC fast, RIL in a timely manner, discuss RIL with the attorney. I'm seeing that a lot. Staff and attorneys have discussion, make sure all information is being put into the system. Speak with counties about the RIL process. Staff often with agency attorney. Let's see if there's anything new. Consult with agency attorney.
I want you guys to know y'all
Sure
make me so proud when I see stuff like this.
Peter.
I was going to say, yeah, the folks at the county level make me so proud when I see stuff like this.
So it looks like a lot of you are going to have further discussion, both with county attorneys and with the staff, to make sure everyone understands the process and make sure that the process is used correctly and that things are entered correctly. Let's see if there's anything else in there that is not covered by that. Having the team view this webinar, yes, you can always do that. And reviewing the policy. Takeaway, RIL is only for adults. All right. It looks like we've got some great takeaways. I'll keep looking and seeing if there's anything new. And I want that Peter and Gail are sharing their contact information. How would you all like for people to contact you if they need assistance?
They're certainly welcome to use my email. I would encourage maybe a first line of defense is maybe through their local regional child welfare consultant. But again, I would never turn anybody away, so emailing me directly is perfectly legit.
And I will, no, sorry, well, I'm probably gonna send you back to your attorney. So just because I have to, it's not because I'm trying to be difficult. So yeah, I would go to your regional rep and your attorney, and I think most county attorneys know that they can come to the AAGs, to kick around Yeah, but we're there as a sort of a resource to kick around some ideas, and they also have, and for the directors on the call, there is a DSS attorney listserv, and hopefully all of your attorneys are on that listserv, and it's facilitated by the UNC School of Government. And there are some really, it's a great resource because attorneys can speak with each other. And so I've seen attorneys, post, hey, does anybody have a go-by, a sample for that thing? As a matter of fact, I think this was recent. Somebody asked about, how do I motion the court for that ex parte hearing? And then they kind of just share knowledge, because there are some folks on that listserv that were doing child welfare before I ever went to law school. So it's a really great resource for your attorneys to use if they aren't already.